那我们十分感谢这个小罗法教授小罗法律师给我们精彩的内容哈。那我这边也要回应一下他最后提出来的一个观念，就是说这个一旦制度形成，这个制度里面的缺失是很难被改变的。所以这边我还要再度对这个主办单位表示我的敬意啊，因为这个在台湾社会里面官方一直有强大的压力，必须尽快的实施这个人民参与审判制度啊，但是一直有来自民间的这个各式各样的这个疑虑啊，让这个进程受到了迟延。但是在这个迟延的当中呢，我们也学习到很多不一样的经验。那从今天这个小罗法教授提到了很多案例，我们都可以看得到，这个一旦这个制度形成之后，它的缺失很难改善啊。所以希望我们在一开始投入的时候就可以走在正确的方向。那么接下来呢，是不是我们在现场开放一个问题，来跟我们小罗法教授来互动？来，请。
It's about national security sensitive evidence. And I can recall in recent cases in the European Court, they have a system of accredited counsel, accredited lawyer system. Only those highly regarded lawyers will be allowed to approach this kind of sensitive cases. Do you have a similar things in the States?
Yes, we do. In cases.
Please wait a moment. 你是我刚才已经翻译过了。OK. Please.
Okay. In cases where the evidence raises national security concerns, the lawyers have to undergo a security clearance. They undergo a background investigation and security clearance. I've done that. Many lawyers I know have done that, especially in the United States where there's an increasing number of terrorism-related cases. It's unfortunately increasingly common that defense lawyers are are involved in cases that involve classified information. That being said, lawyers will have to undergo and pass a background check and get appropriate security clearances, but that doesn't mean that they just get access to the information. There's still a lot of litigation around what information is actually disclosed and provided, and there is something called the Classified Information Procedures Act, which governs the production of that kind of information. So that's a very complicated, separate area, and I think like I said, I think that it's appropriate to treat that as its own category. It's difficult to do that because it's very easy for the government to say, well, this is a national security concern. But I think that, we have to, there has to be some flexibility to allow the government to take appropriate action to protect the country as a whole, or in other cases where you might have very vulnerable victims, that there may be compelling reasons to restrict access to evidence. But we do have a procedure for clearing lawyers to see such evidence.
May I have one more comment about the preaching evidence you just mentioned? I think if the public prosecutor, especially the federal prosecutor you particularly mentioned in your speech, if they do have the legal obligation to do the disclosure, then the prosecutor shouldn't prosecute in the first place. So it's a dilemma. So if the law requires the public prosecutor to disclose something that will doom them to fail, then for me, it's impossible for them to ask them to say, sorry, I made a wrong prosecution in the first place. That's very complicated tautology.
Yeah, no, I think you're raising an important point. I think what happens is in many investigations, there's evidence that is incriminating or tends to show that somebody's guilty, but there may also be evidence that tends to show that somebody's not guilty. And in the United States, the system is designed to enable both parties to take that evidence and advocate their position, and then let a separate body, the jury usually, or sometimes the judge, decide, whether or not the evidence is sufficient to prove guilt. And if not, then the person is deemed not guilty. I think what happens is most prosecutors, they feel that they've ideally, in theory, the way it should work is the Department of Justice is trying to reach a fair result. If they think that there's enough evidence to bring a case, if they think there's probable cause, they'll bring the case. But but that doesn't necessarily mean the person's guilty. That's a different standard from the standard of proof at trial, which is beyond a reasonable doubt. So they might bring a case thinking, well, we think it's more likely than not that this person is guilty, but even if there's evidence tending to show that they're not guilty, and they should be willing to let the evidence speak for itself at a trial and let a jury decide what the ultimate decision is. But I think that what happens often is, even with the existence of evidence favorable to the defendant, the prosecutors have become so persuaded of the defendant's guilt based on other evidence that they don't believe that exculpatory evidence, or that evidence favorable, is really material. They don't think it would change the outcome. So, that's why I think the problem that you're raising is the reason that I think it's very problematic to put the burden on the prosecutors to identify evidence that's favorable and material to the defense. I don't really believe that they are in the best position to make that decision for the reasons, Professor Jin mentioned yesterday, he talked about tunnel vision. That is a real problem. So I think that there are ways you can structure the system to avoid that, and that is by changing the standard and requiring disclosure, not asking the prosecution to try to identify information favorable and material to the defense.
好，那今天因为时间关系，我们中场要先休息一下，那稍待，在3点15分，我们3点15分再回来继续，谢谢。